Everything you need to know about product. Everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
And welcome back to QuayPaciffic's Talk About Strata. If you have questions at any time and you'd like to reach us and have a response on air, you can email us at questions@talkaboutstrata.com. That's questions@talkaboutstrata.com. It's a new year, and I have Adrian Murray from Hammerberg Lawyers in the studio. I was about to say the office because we spend so much time in offices together sometimes. And we're talking about rental bylaws, some of the case law, some of the complications, and we're talking about how it affects buildings differently, and it certainly has a different impact on buildings, whether you were a building that was built prior to 2010 and buildings that were built and completed and the developer filed documents after 2010. One of the things that came up out of our earlier conversation is the need for strata corporations to have a copy of their rental disclosure statement if one was filed by the owner developer. And we get it through the Superintendent of Real Estate's office. And it's not only a document that's necessary for rental bylaws to understand how that rental bylaw will impact the people in the building and to help us understand how many people will be influenced, but it's also a document that's necessary on a Form B, has to be attached to a Form B information certificate when a buyer comes along or somebody's requesting an information certificate. So, you know, maybe for stratas we should make a generic New Year's resolution. My wish for every strata this year is that every strata council has a complete set of their legal and governing documents so that strata councils can make responsible decisions. You have copies of all your registered bylaws that were ever filed, all the rules that the strata corporation ever filed, rental disclosure statements, copy of your strata plan, your unit entitlement, your voting entitlement. All of these documents are absolutely critical to the governance of your strata corporation. And of course, as you get through when you start enforcing bylaws, understanding how those documents apply would certainly be significant.
Absolutely. And speaking of the rental disclosure statement, it becomes even more critical when we're looking at passing a rental bylaw in a newer building.
So a newer building is going to be post-January 1st, 2010?
Well, it's not the construction, it's when the rental disclosure statement was filed. So the building may have been constructed or maybe in the process of being constructed but wasn't finalized until 2011. But the rental disclosure statement was filed with the disclosure statement in 2010 perhaps. So we need, the real key isn't when the strata plan was created or when the building occupancy permit was issued, it's when the rental disclosure statement was filed. So the Strata Property Act specifically provides that where a rental disclosure statement is filed after December 31st, 2009 or
right.
January 1st, 2010, then there are certain restrictions in a strata corporation's ability to rent the strata lot. So the legislation was changed about 3 or 4 years ago to restrict a strata corporation's ability to pass rental bylaws. And I know that a lot of people find this somewhat concerning, but they're generally speaking in the province, it is my understanding that this was initiated because of a concern over the lack of rental stock
right.
in the province entirely, and the desire of strata corporations to restrict on a very large scale basis the number of rentals. So what the legislation did was to say that, as I mentioned earlier, every developer files a rental disclosure statement, but initially, that rental disclosure statement would apply to the developer and first purchasers. So that once that, even if it indicated it was to expire in 100 years from now, once that first purchaser sold their strata lot, the rental disclosure statement no longer had any impact or effect.
So my 20-year-old building, we pass a bylaw. 5 people are still original purchasers. There is a rental disclosure statement that exempted the owner-developer from rental bylaws. So those 5 people who are the first purchasers who still live there would be exempt from the rental bylaw if we adopted a rental bylaw.
That's right. And even if the rental disclosure statement indicated it was valid until the year 2099,
right.
only those 5 who were the first original purchasers. So
right.
notwithstanding the expiry date of the rental disclosure statement, only the original purchasers from the developer would be would benefit from that rental disclosure statement would be able to rent their strata lot.
And we've had a number of the rental disclosure statements before 2010 frequently don't have a date. They frequently will say the owner or developer may rent or intends to rent indefinitely.
That's right. And we've had a court decision called Spagnolo,
Right.
which upheld the validity of those. There was some question as to whether a rental disclosure statement that said indefinite was valid. And in the Spagnolo case, the court agreed that the rental disclosure statement, notwithstanding that it didn't have an expiry date, would be valid because it expired anyway once the first purchaser sold.
It's never going to be without any limitation because at some point the first purchaser is either going to sell or they may also die and the property transfers ownership
That's
through
right.
an
That's
through
right.
an
So
estate.
it's going to come to an end
In any
based on
case.
other circumstances.
Right.
So then getting back now to the change in the legislation, what the legislation, what the drafters did or the government did was amend the provision of the rental disclosure statement to say that it now applies in all cases until it expires. So it applies to the developer and the first purchaser and the second purchaser until the rental disclosure statement expires. So the legislation doesn't specifically prohibit the passing of rental bylaws, rental
Right.
restriction bylaws, but what it says is the rental restriction bylaw is not applicable to those strata lots where a developer has filed a rental disclosure statement after December 31st, 1999.
Right.
Sorry, after December 31st, 2009,
Right.
until the rental disclosure statement expires.
So this rental disclosure statement really applies to the strata lot. It runs with that strata lot
Absolutely.
regardless of who owns
That's
it
right.
now.
There's no
Right.
issue now as to whether you're the first purchaser or not.
Right.
So we're seeing rental disclosure statements that may be valid for 5 years.
Right.
They may be valid for 50 years or 100 years. Now, another interesting twist is prior to this change in legislation, if I was the first purchaser from the developer, I knew that I was always protected from a rental bylaw.
Right.
Now, not the case. I'm only protected, even if I am the first purchaser, I'm only protected to the expiry date of the rental disclosure statement. So even as first purchasers, I may find myself subject to a rental bylaw if the rental disclosure statement has expired. If
So,
it was issued after December 31st, 2009.
And we've certainly seen that already. We've seen also conditional rental disclosures that say things like the rental disclosure period exemption expires when the developer sells or conveys the last strata lot. But that's not really consistent with the language of the legislation.
Well, there'd be some question as to the validity because it does require that it has a date
Right.
now, which is, again, addresses the idea of indefinite
Right.
and addresses these conditional or subjective type of arrangements. But for a strata corporation then, if you're a strata corporation that's relatively new or you've been constructed somewhere around 2010, it's absolutely essential that you look at your disclosure statement. Now we're looking at two things. We're looking at the expiry date of the rental disclosure statement, and we're looking at the date it was filed. So if the rental disclosure statement was filed on January 1st, 2010 or later, now our rental bylaw can only become effective when that rental disclosure statement expires. So frankly, there's no point in
Right.
passing a rental bylaw
Right.
if in fact the rental disclosure statement is valid until the year 3000.
But if the rental disclosure statement is only 5 years long, and we're in a high-rise building that's 3 years old already, we could pass a rental bylaw now, knowing that when the rental disclosure period expires for everybody in the building, that they no longer will be eligible to rent, or there'll be a limited number of rentals.
We can, and again, I think there's a couple of things that are going to come into play here. When you pass a rental bylaw, it automatically does not take effect for a year.
Right.
So passing it a year before it even becomes effective is
Right.
not a bad idea at all,
Right,
because
right.
now you've eaten up that grace period, so
Exactly.
to speak, with part of the rental restriction or rental disclosure statement grace period. The other thing is you have to be very, very clear, and I think it's incumbent on strata councils and the strata management companies, if they have a management company, to make sure that owners are advised of how this is going to apply, because it's if we're passing it in advance of its applicable date. We want to make sure that everyone knows that, yes, we understand what's going on.
Right.
Here's the date where it's going to become effective. So you consider the date of the rental disclosure statement, you consider your grace period provided for under the Act, and then we've got a start date. And that start date's for everyone now, and will apply to original purchasers,
So
which
if
may be shocking.
So if I'm an investor, this is probably pretty critical information for me, and I'm looking to buy one or more condo units, and I want to rent them out. That rental disclosure statement is probably going to be one of the most critical documents I can look at, especially if that rental disclosure statement was filed after January 1st, 2010. And it provides an extended period of time for the exemption, because it would essentially mean I wouldn't be affected by the rental bylaws if my unit was going to be affected under the rental disclosure statement. If it's going to be exempt, I buy 2 units where the rental disclosure statement was filed after January 1st, 2010, and the period of time doesn't expire to 2050. As an investor, I know that whether I'm the first or subsequent purchaser, it doesn't make any difference.
Well, that's right. And the other thing is, the investor is, you can sell it.
Right.
See, the difficulty right now with anything that's a rental disclosure statement pre-2010 is, I'm an investor, I've bought it, I can rent it, and I can rent it forever. But when I want to sell it, if the Strata Corporation has a rental restriction bylaw, that rental restriction bylaw is going to apply to it.
Right.
So my market will be limited to non-investor purchasers. If I'm buying a rental unit under a 2010 or later rental disclosure statement, and the expiry period is way off into the future, not only do I have the benefit of assurance of being able to rent it, but I can sell it as an investment unit, which expands the marketability of it. So it's got the advantage. And of course, on the flip side of that, if I've got if I buy into a building where the rental disclosure statement's about to expire fairly soon,
Right.
then notwithstanding that I'm the first purchaser from the developer, I'm going to be subject to a rental bylaw. And that's what investors are finding a little harder to come to grips with, because
Right.
there's this continuing view, historic view, that if a first owner from a developer has the right to rent.
Right.
Not anymore.
Right.
So it's all about the expiry date on the rental disclosure statement.
So it's a pretty critical document that people have to look at, and that's obviously one of the issues that we deal with on a regular basis, is the lack of good documentation that strata corporations, that property owners and property managers have in their hands to be able to make decisions on factual information.
Right.
That's without a doubt, that is one of the most predominant complaints I think that our offices across the province are exposed to.
We make a lot of assumptions. We see a lot of owners making assumptions, a lot of strata councils and strata managers making assumptions. Well, this is the way it's always done, or
Right.
All balconies are all limited common property. Wrong assumption. You need to look at the documents to determine what in fact is happening in this particular building.
Which is why buildings are local for each community. And bylaws themselves, they affect, like your strata corporation is its own little local government, and your bylaws apply just to your strata corporation. I'm Tony Jan14th, the host of QuayPacific's Talk About Strata. In the office, I said the office again. In the studio, I have Adrienne Murray. She's a lawyer with Hammerberg Lawyers and specializes in strata law. And we'll be back in a few moments just after these messages.
There's still more ahead with Experts on Call on CL 650.